All right, good morning. Welcome to the 294th District Court. My name is Chris Martin. I'm going to call this morning's criminal docket. When you hear your name, please say present here. Matthew Estrada. Here. Jodine Lewis. Randa Opa. Here. Monica Roberts. Jasmine Woods.
Cook County.
Thanks, sir. Mr. Allen, correct?
That's correct, John.
Thanks. Diedrich Sibly. I believe that Mr. Sibly may be running late, so we'll recall him. For the record, cause number CR 21-262. Ms. Lauren Jean Foley was reset from last week after trial to this week. I believe that the state's aware that Mr. Ashmore requested that her case be moved to Thursday. The court granted that, so we're going to reset Ms. Foley until 15th. Sentencing. Eugenio Gonzalez Merlo. I believe that Mr. Gonzalez Merlo may still be in federal custody or custody of the state of Florida. Mr. Estrada is going to be appearing by soon. Mr. Hernandez, so we'll bring him in a moment.
Thank you.
Raimundo Flores. Raimundo Vaga Flores. I think that we're going to recall that one and discuss that one. There may be an ice hold on this justice. Kenneth Lee Taylor. Katie Williams. Katie Renee Williams. Johnny McMinn. Johnny Lee McMinn. David Shields. All right, is there anyone who's present in the courtroom and I've not called your name? All right, do we have any counsel that's ready? No eager beavers today, I tell you what. Y'all need time to talk with the state? I got other things I can call. Y'all need time to call.
I'm ready.
You ready? Okay. All right, Mr. Allen. You're coming on. Jasmine Woods, CR 24-10. Jasmine Woods, come on up. And we'll be right there. All right, Mr. Woods is set for arraignment today on manufactured delivery of a controlled substance, Millie Group 1 greater than 400 grams. Mr. Allen, have you had a chance to review the indictment of your client?
We have, Your Honor.
Are you ready for arraignment?
Yes, I think we are prepared to waive formal arraignment. Enter a plea of not guilty, and we just need an opportunity to secure the discovery.
Is his name spelled correctly in the indictment?
It is, Your Honor.
All right, the court finds that Mr. Wood's name is spelled correctly in the indictment. He's waived the formal requirements of arraignment. Court will enter his plea of not guilty into the record. And what I do, Mr. Allen, is I will set the standard pretrial hearing, and I'll set that out at least 30 days. We'll look at your calendar in just a moment and see if we can find a date that's good for you as well. And so once that pretrial comes and goes, I expect, what the code requires is that you'll file any contested pretrial motions, motions to suppress, quash, whatever. And then if you still have discovery issues, we can reset that pretrial hearing. Once we get past that, then I'll set it for docket call, and that'll be a time that all of the negotiations will take place. And then you can report to the court whether he wants it enter a plea, trial by court, or trial by jury.
Okay.
All right, Mr. Woods, if you have your calendar, go ahead and look at it. I've got February 26th. I'm sorry, March 26th. And April 16th. Those will be my next two criminal dates.
Okay.
So those dates are March 26th and then April 16th.
Okay. Let's do April 16th.
April 16th. All right, court sets Mr. Woods for pretrial hearing April 16th at 9 a.m. And Mr. Allen, have you already got online discovery from the state?
No, not yet.
Okay, so you'll need to meet with them today and get all that worked out so that you'll have access to the electronic portal and then take up whatever issues you have with the state.
Okay.
All right. And so, Mr. Allen, if you'll sign and have your client sign as well, the notice of hearing form. The white one will stay with me, the yellow one will go with your client. Mr. Allen, where do you office?
Dallas.
Yes, good to have you here.
Thank you. Nice.
Good evening, Mr. White.
Hey, Your Honor.
David Shields, CR 22-363. All right, Mr. Shields is set for pretrial. Go ahead, Mr. White.
Your Honor, I don't believe I have any pretrial that is being contested. It's the same three motions I do, but I would be asking for another pretrial. And I think it's partially, well, greatly my fault. I was thinking I didn't have the DVDs, and evidently I did get them back around 2022. And at this point, I don't think I can find them, but I need to look at them again.
Have you reviewed them already, though? You just need to re-review them.
I can barely remember what happened yesterday, much less 2 years ago.
All right, any objection from the state on?
No, Your Honor.
The pretrial hearing. All right, we'll reset Mr. Shields for the additional pretrial hearing. Mr. White, we can do something. March 26th.
Is that a
You say,
Tuesday? That sounds great, Judge.
all right, court sets Mr. Shields for an additional pretrial hearing March 26th. Who would you like to call?
Kenneth Taylor.
Kenneth Taylor. This is cause number CR 22-195.
That's correct, George. We were set for docket call and asked for an additional docket call setting. Mr. Taylor's been undergoing serious treatment for some major healthcare issues, so we've been out of touch for a while. I think that the state's reassigning this case to a new prosecutor, so we'd ask for some more time to attempt to resolve it.
Any objection from the state?
No objection.
All right, court will set Mr. Taylor for a final docket call March 26th. Are you available?
I'm not, Judge. I am on that April 16th date.
April 16th. All right, court sets Mr. Taylor for final docket call April 16th.
Want to do it?
Can we talk about Mr. Flores? Just on the record. Just let me call this for the record. Call number CR 23-150 State versus Bill Vago Flores. Sorry, Mr. Flores.
He was in custody, I guess it was a year and a half ago. At the time, he had an ICE hold. We PR bonded him out. It's my understanding he was deported at that point. I think ICE executed their hold. Gee whiz, it had been 18 months ago, and I haven't spoken to him since then. So I presume he's either out of the country or he may be back in, but I would say.
What's the position on your prosecution, Mr. Flores?
Your Honor, if we could get just a couple of weeks to try and confirm, Mr. Flores' status. And, I hate to set it out again to get the court a final order, but if we get just a couple of weeks to try and confirm that, I think it will help inform our decision.
All right, court will set Mr. Flores for status on prosecution on April 16th. And if you just, I guess what I've got to determine is one, do you want to continue your prosecution? If so, then does he have, we do an alias capias? Is he in custody somewhere? Just need y'all to determine that. I think y'all have the greatest access to that information.
Yes.
Mr. Schmidt, any word from Katie Williams?
Judge, that was a prior appointment. I don't think that, I talked to Ms. Abraham this morning. I have not been reappointed to represent her on the MTA. I did see my name on the docket. However, I have not talked to her, so I don't believe she's filled out the paperwork for.
Okay, I will mark you on that.
Yes, sir.
Matthew Estrada. This is cause number CR 20-40, State of Texas versus Matthew Estrada for amendment to conditions of probation. Mr. Estrada, are you asking the court to extend your probation an additional year? And why do you need to extend it for an additional year?
So I can make all my payments, get everything caught up. I'm a little behind, like procrastinating at the beginning of my probation.
Do you feel like if I extend it an additional period of 1 year, you'll be able to get caught up and comply with probation?
Yes, sir.
Are you asking the court to extend it because that's what you're wanting the court to do?
Yes, sir.
Once threatened you, forced you, pressured you to extend your probation.
Okay.
All right, court will grant the amendment to the conditions of community supervision, extends Mr. Estrada an additional period of 1 year. Your new expiration date, Mr. Estrada, is April 5th of 2025. And during this period, you will be ordered to pay probation fees and your analysis fees. So the quicker you get it caught up, the more money you can save. Because if you get caught up during your extension period and you've complied with everything else, I'll grant you an early dismissal from that extension period. The longer you stay on it, the more you pay. Make sense? Okay. All right, Mr. Estrada, come over here and see. I want to say officer. So, officer.
That was just for me.
So we're in a badge and make it easier for.
Yeah.
All right, Mr. Estrada's in soon. I'm gonna go ahead and bring them in. Morning, Mr. Estrada. I think you're on mute.
Is that better, Judge?
Yes, sir. Much better. Good morning. How are you?
Good morning, Judge. I'm in Wood County this morning. I'm usually in the office. I'm working on my vehicle right now.
No problem. Understand. This is cause number CR 22-374 and CR 22-375, State versus Eugenio Gonzalez Merlo. And I believe that we were set just today for status on Florida custody. Any information for the state of the court?
Yes, Your Honor. And I shared some documents with the state last week reflecting the current status. There is actually a hearing scheduled for February 15th on the custody matter. It's a sentencing hearing on the 15th of this month. So we should have a resolution and we should know what sentence the defendant received by next week.
Excellent. All right. I appreciate that info. All right. Court will reset. Mr. Gonzalez Merlo, are you available on March 26th
Yes, Your Honor.
Let's go ahead and set Mr. Gonzalez for, I'm not sure where we were before we went on to custody status. I don't know if we guys, I'll have to look that up to see if we've gotten past arraignment or pretrial. Do you know off the top of your head, Mr. Estrada?
No, I don't, Judge.
You know, to your knowledge, have we ever had him here in our custody?
He has been, as I'm trying to recall if I've ever appeared with him or he's been in custody. And actually, he has appeared in the past.
So what I'm gonna do, I'm gonna call it a bench warrant status. We'll see after his sentencing, what if the state has a different positions or request. And so we'll just put bench warrant status. And then if between now and then with the state, depending on what the sentencing is, if the state wants to bench warrant him, then the state can submit that request in the interim. And the court would obviously grant that, and we can make arrangements to have him here from Florida on March 26.
Yes, Judge.
And then Mr. Estrada is, I'm assuming that you're going to be made aware of that sentencing on Thursday or after sometime soon after Thursday. Is that correct?
Yes, I will, and I'll share any documents that I receive with the state.
Excellent. That's what I was going to ask you to do. Okay. All right. Thank you, Mr. Estrada. We'll see you back on March 26th.
Yes, Your Honor.
Thanks,
Thank
sir.
you.
You're welcome.
Bye-bye.
Yes, please. All right, court recalls, calls number CR 23-150, State versus Raimundo Vaga Flores. All right, the state has tendered to the court a motion to dismiss, indicating that the defendant has been deported, correct?
Yes, Your Honor, I was just able.
Thank you for looking that up, Mr. Merlo. All right, then the court grants this motion to dismiss and signs the order dismissing the case. Yes, sir. A copy of that if you want to. Just give that to Ms. Peggy here. Randa Opa. All right, remind me, is it Opry or Opera?
Oprah.
Oprah. Third. All right, Ms. Oprah, this is a sanctions court hearing. Cause number CR 22-280. Probation department's indicating to the court that they're trying to get information regarding your mental health evaluation. They said that they don't have any of the documentation that they requested and that you've been unable to provide any of those supporting documents.
Those documents here this morning.
Did you turn those into your probation department?
I emailed it to her, yes, sir. And I have a copy for myself and a copy for the court.
When did you email it to your officer?
Yesterday.
Who is your officer?
Ms. Mewborn.
All right, Ms. Obrey, I want you to do this. I want you to go ahead and take that paperwork.
Mhm.
Go over and meet with your probation officer, Ms. Mewburn, right now. Give all that to her, make sure that that's exactly what she needs, and then come back to the court.
Okay. Yes, sir. Thank you. Do y'all need a copy of this also?
Copy of what? No, just give it to Ms. Mewburn, and then she'll take copies of whatever she needs, and then she'll let us know if you're good with them. If not, then she'll let me know. All right, so
Okay.
go meet with her, show her what you got, make sure that she's satisfied, and then come back over here and we'll talk about the next step.
Okay. All right. Thank you. Yes.
Coding Lewis. All right, Ms. Lewis, this is a sanctions court hearing in cause number CR 22-357. Ms. Lewis, is this your first time in sanctions court? Yes. Do you understand the purpose of sanctions court?
Yes, sir.
Tell me in your own words what sanctions court means to you and its purpose.
It's, I guess it's, something that you've done wrong.
You know, that could be a consequence, but what do you believe to be the purpose, if you know? What's the purpose of sanctions court?
Show you that there's consequences for things that you do, whether they're good or bad.
True, I agree with you on that. Would you also agree with me that sanctions court is an effort to help you become compliant before you get revoked and sentenced on your charge?
Yes, sir.
Okay, so the purpose, sanction court is to monitor, and when the court finds that you're committing violations of your community supervision, if they're not significant violations, it's an opportunity for us to correct your behavior, try to prevent you from being further prosecuted and sentenced on your charge. And in your case, it appears that you were convicted back in March of last year for the offense of possession of a controlled substance, a third-degree felony, and your sentence was 8 years confinement in prison. Is that correct?
Yes, sir.
And that 8-year sentence was suspended, meaning that you don't have to serve that sentence right now. You're being allowed to serve your sentence in the community on what's known as probation, community supervision. You understand that?
Yes, sir.
And I see here that the probation department is reporting to me that you violated your community supervision by admitting to drinking alcohol in April of last year, I believe. Is that correct? That's correct, sir. You understand that the state of Texas, through its probation department, could right now just file a motion to revoke you and ask the court to sentence you to those 8 years. Yeah, we're not doing that today. We're here at sanctions court to give you an opportunity to see the error of your ways and give you, albeit probably a second chance now, or a third chance to avoid that prison sentence. Understand that? You understand the gravity of what's going on here today?
Yes, sir, I do.
While drinking alcohol might seem insignificant, it's very significant for someone who's on probation for a third-degree felony who's got an 8-year sentence. You understand that the sanction for drinking alcohol would be 3 days in jail. You understand that, if given that opportunity, if you accept that sanction, that you're gonna serve 3 full days of jail.
Yes, sir.
And after that, you may be brought back to sanctions court for monitoring. And, it looks like you're delinquent on your community supervision. In fact, you did work some this month, but you're still about 25 or so hours behind your community supervision. You've already worked some, but looks like you're falling behind on that. So it's likely that you're gonna remain in sanctions court until we get you back on the right track. Are you gonna be able to comply with your probation?
Yes, sir.
All right, Ms. Lewis, then what I would do is I would order you as a sanction to serve 3 days in jail for your admission to drinking alcohol. I'm gonna let you pick the 3 days that you serve. Are you working?
Yes, sir.
You work weekends or during the week?
No, not weekends.
On weekends. So you could go in and serve your time on weekends. So it doesn't affect your job. All right, so what I'm gonna do, Ms. Lewis, is I'm gonna reset you for an official sanctions court hearing on March 26th. And I'm gonna order that you serve 3 days of jail. And I'm gonna order that you do 15 hours community service. You're ordered to do 10 every month anyway, but I want you to do 15 this month. And that's gonna make it a little bit harder because you're gonna lose a weekend, but you're gonna have to serve at the jail. But I want 15 hours of community service so that we can get you caught back up. Okay. Is that a sanction you're willing to accept?
Yes, sir.
Then I want you to come over here, see Officer Matura, and she's gonna get your information about that, the 3 days in jail. And when you go, you will have to take a copy of the order that I signed, along with, picture ID, so that they can verify you are. So if you show up without either one of those things, they're not gonna let you in jail. And they're just gonna notify me that you didn't show up with the correct stuff, okay? All right, so I'm gonna give you a reset notice here, saying that we're gonna come back on the 26th so that I can see that you did what I asked you and told you to do. So sign this, and then it's got your date on there. We'll give you a copy, and after you get that, go over to the Officer Matura.
Thank you, sir.
All right, Ms. Roberts. This is cause number CR 22-224, State of Texas versus Monica Rochelle Roberts. All right, Ms. Roberts, it appears that I think we were going to be set for sanctions court hearing, but the probation department has indicated that you may be considering serving a term in the substance abuse treatment facility. Is that right?
I don't want to go, of course, to the safety. I went to my probation meeting this morning and she told me that if I didn't agree to the safety, that she would put a warrant out for my arrest and then I would just be sitting in jail. I know, I mean, I went through some stuff. I did go through some stuff and I drank alcohol. But I'm just need another chance. I mean, I'll take weekly drug tests. I'll do whatever I need to do. I drank alcohol. I made a mistake. I live with my mother. She needs me there. We have my 14-year-old niece that lives there. My sister died in 2016 and I helped my mom. And I went through some things in December. My granddaughter had botulism, she was in ICU. And I was staying in an RV over there because she was 3 months old at that time. And when I was staying in this RV, they told me that they were going to sell it. So I had to be out by the 1st of the month.
And let me pause real quick, because I don't want you to disclose too much.
Okay. I went through a lot. I made a mistake and I drank.
Yeah, I understand. So I guess I need to tell you where we're at in this. I don't have a report in front of me that tells me what you did when you did it. I don't have the probation department recommending a sanction. I don't have the probation department or the state having filed a motion to revoke your community supervision. They sent this to me indicating that you had agreed to do the substance abuse felony punishment. If that's not your agreement, then what I'm gonna do is I'm just gonna dismiss you today and then let the probation department decide what they want to do.
She told me that she would put a warrant out.
That may be, that's their job as the probation department, is to make decisions and recommendations and consult the state and determine what they want to do. So what I'm telling you today is that what's in front of me is not a request to sanction you. It's not a request to revoke you. What was in front of me was to discuss whether you're agreeing to amend your community supervision to include the safety punishment. And it sounds like to me that that's not your agreement today.
How long is the safety? I don't know. Is there any other way I could like do counseling or?
Well, I don't want, it's not really appropriate for the court to discuss all these things and tell you what your options are, negotiations with the state of Texas with the probation department. So if you want to have those conversations, you'll need to have that with the probation department. Your probation officer.
She won't listen to me. I don't know how to have a conversation with her. I really don't.
I understand. So that's kind of where we're at today. You certainly don't have to agree to this. So that's where.
So then if I don't agree to it and I go to jail, I'll be faced with the original sentence, or I don't understand.
So right now you're on community supervision.
Mhm.
As you stand here today, a motion to revoke your community supervision has not been filed.
Okay.
Apparently there are some issues. I don't know what they are. I don't have a sanctions report telling me what you did, when you did it, or how you did it. And I don't have a revocation motion in front of me. All I have is an amendment to your conditions of community supervision. So as you stand here today, you're still on community supervision. If this is not your agreement, then I'll just report back to the probation department that you appeared today and you're not wanting to agree to this. And you can work with them on trying to figure out some other alternative. They may agree with you, they may not agree with you. They may decide to ask the state to file a motion to revoke, which would result in that warrant that the probation officer has referenced. And then if that happens, then yeah, you would be arrested on that motion to revoke. You can sit in jail. You hire an attorney, you can afford one would be appointed to you if you're indigent. And then at that point, your negotiations with the state would start on how to resolve your case based on whatever the alleged violations are. But that's procedurally how things work. So at this point, as you stand here today, you can agree to amend your community supervision conditions and you can go to the safety program, or you cannot. And
How long is the safety program?
the safety program is I think it's a minimum of not less than 6 months or more than 1 year. Typically it's 6 to 9 months with 3 months aftercare before you go back on community supervision. So if you have more questions about that, then what I would recommend you do today is go back to your probation officer and sit down and ask specific questions. That way you can make a decision, an informed decision as to whether that's what you want to do. And then the probation officer can also talk to you about potential consequences of agreeing to it, not agreeing to it, those things.
Okay.
Does that make sense? So do you want to go back over to the probation department and meet with them and discuss it further? Or do you want, or do
Well,
you go?
if I go back off there, she'll put a warrant out for me and then I'd be arrested. If she says no,
If she says no to what?
to like motion to provoke.
I'm not sure what your probation officer's, decision would be. I'm saying that if you want, you're asking me questions about the safety program. They're much more knowledgeable about that. I can give you the basics, but if you have specific questions about how long it is, what happens until you get there.
I asked her questions. I'm sorry, I didn't.
That's okay, go ahead.
I asked her questions and she said that the court would explain that to me, that she didn't have knowledge and didn't know like the basic, and I mean, she just knew it was a substance abuse, but
Who is your probation officer?
Stephanie knew.
All right, well, let's do this, Ms. Roberts. If you have questions about the safety program, Officer Ventura is very knowledgeable about it. She said that she'd want to talk to you about it at this time. So I can give you a moment, let you come over here and go in here and have some privacy with Officer Ventura, ask your questions, and then you can make an informed decision on what you want to do today. Okay?
We just got.
Oh, file this video. She has some information. All right, for the record, file number CR 22-299, State versus Katie Renee Williams on motion to adjudicate. Ms. Williams' name has been called loudly distinctly 3 times in the courthouse with no response. Ms. Williams was given notice to be here at 9 a.m. this morning. Ms. Bell to review. File number CR 23-61, State versus John Williams, and Mr. Be here at 9 a.m. Is not present. Court has received information that Mr. McMahon may be reporting to the Ramsey County Justice Center at 1:30. Plea. This time the court is going to issue an alias habeas judge of Nassau and Katie Williams. And the court will issue an alias habeas judge of Nassau on Johnny Lee. And the court will hold that under advisement until 1:30. See if Mr. McMahon reports to justice. So I believe that concludes the morning docket. Is that correct?
I believe so. I believe this will probably just come back and check in before.
Yeah, that's a sanctions court hearing, so. Yeah, I'm gonna tend to her. You're welcome to stay for that. Welcome to leave if you want to.
Thank you, sir.
I'm gonna order her back, and sanction her. This is on it. Of course, I'm staying in the recess for about 20 minutes.
Yes.
All right, Ms. O'Brien, we are back on the record with regard to your sanctions court and CR 22-280. So after you met with the probation department, they've indicated to me that the paperwork that you have is either out of date or insufficient, and they're asking the court to order you back to completing or providing a new mental health evaluation.
Yes,
That you can get that through the Andrew Center, either in Wood County or here, it doesn't matter.
I had actually yesterday, the lady on the form here, Kevin. I'm already familiar with her because I kind of. The services received from the center, so, she said that would be fine with her, that to call her the last week of February and get on her, schedule for March. Would that be okay?
Yeah, that's fine. So what I was gonna do is I was gonna order you back on April 16th. That time, I can get that done.
Okay, thanks.
So I just want you to go and get that taken care of, and then we'll come back on April 16th, show me that you've done that, take care of it, then I don't think I'll have anything else to do. Be back on your probation, okay?
Okay, all right.
Any questions? All right, Deputy Martinez is gonna bring you a form here, sign that, and then he'll give you a copy,
Okay,
and then you take care of that, we'll see you back on April 16th.
okay. Does it have the date on here?
Yes.
Okay, all right, thank you.
And Ms. Oprah, I'll tell you that if you get this done and satisfy the probation department, it's very likely they'll call over and tell me that you've taken care of everything. They don't want you back in sanctions court. If that happens, then we can cancel that court date. But
Okay, but I'll be notified of that.
you would be notified of that. But if you, I'm just telling you, get on it, get it taken care of, satisfy them, then they can tell me that they don't want you here. And I'm good with that.
Okay,
Okay.
okay, sounds good, thank you.
All right, Mr. Sibley. Well, there's good, Mr. Sibley. All right, this is in reference to a extradition. So, be on record. This is in reference to the matter of fugitive Dietrich Bell Sibly, fugitive one number 23-1212. Sheriff's Office. All right, so Mr. Sibley, you and I met back on December 12th of 23. And at that time, I had informed you that you were being detained in our custody on the warrant from the parish of Bossier out of the state of Louisiana. And they had indicated in their warrant that you were wanted for 3 counts, two of simple burglary, a felony, and 1 of aggravated burglary, that's felony. You and I talked about those things that day. We talked about your right to extradition, and you ended up waiving your right to extradition and indicated that you would voluntarily go back to the state of Louisiana to resolve your charges. The Van Zandt County Sheriff's Office on that day notified Bossier Parish that you were free of local charges, ready and available to be picked up. As you're aware, I'm aware, you sat there for 30 days. They didn't pick you up, and I told you at that time that if they didn't pick you up, I would bring you back and we'd talk about it. And so you and we met again on January 12th, and that's when I granted you bail because the state of Louisiana had not contacted Van Zandt County, indicating that they were going to pick you up and affect their warrant. So that's when I granted you a bond. I ordered you back here today so I can find out if there's any more developments on that front, whether or not the state of Louisiana contacted the sheriff's office to take you into custody. We've still not heard anything from Bossier Parish. Okay, so my sheriff's office contacted them again back on January 5th. the second time indicating that, you were available for pickup. That was prior to you being released, on bail. And so at this point, Mr. Sibly, I don't have any indication that the state of Louisiana is going to come and take custody of them. So I've issued an order today releasing you from any further obligation regarding this specific one. Okay, so I'm gonna give you an order that outlines all of that. That doesn't mean that the state of Louisiana will issue a new warrant and ask that you get picked up again. Okay, so my best advice to you is, if you're concerned about that happening, is to voluntarily go back to the state of Louisiana, try to resolve the charges, address them. That way you can go about your life. You don't have to worry about every time you get your driver's license renewed, or you get stopped, or you have any kind of contact with police officers, because they very well could, after receiving, we're going to send this to the state of Louisiana. Once they see this, they're going to know that that warrant has been affected. They didn't take custody of it, so they dropped the ball on it. That doesn't prevent them from doing it again. So double jeopardy on issuing a new warrant. Okay, so my advice to you is, if you want to get that taken care of, is to go back there, show up there, talk to your probation officer or whoever. Were you on probation there? No, you weren't. Okay. So anyway, they've got charges for you. So my recommendation is go handle those in Louisiana. You won't have to keep getting arrested here in Texas counties and then waiting to see what they're going to do. And they may dismiss it, they may not. I don't know. That's just my advice to you. Ms. Abraham's going to give you a copy of everything that we did here in Van County, so you can have that for you for your records in case you get stopped. All right, you're free to go. You're welcome. All right, Ms. Roberts. All right, we're going to go on the record. This is cause number CR 22-2. We're in the state of Texas versus Monica Michelle Roberts regarding amendment to the conditions of probation. All right, Ms. Roberts, we met earlier and we discussed a possible amendment to your probation to include leading safety program, substance abuse, felony treatment facility. You had questions about that. I allowed you to speak with Officer Ventura. Was she able to answer your questions? All right, do you have any other questions that the court, the probation department could answer for you with regard to the amendment to your conditions of probation? Okay, and have you had some time to think about whether you want to amend your conditions of community supervision or not?
Does that mean like go?
Have you had enough time to think about what you want to do after having talked with Officer Ventura?
Yes.
Okay, and what decision do you want to make today?
I'll go on to say.
Want to safety? All right. So I'm going to put you under oath in just a moment. I'm going to ask you if you're doing that potentially knowingly, voluntarily, make sure you don't feel like you're pressured or coerced. Okay. Like you raise your right hand. Ms. Roberts, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God. All right. So Ms. Roberts, if you amend the conditions of your community supervision, it would include a couple of things: additional court costs, that you would be placed in the substance abuse felony treatment facility for safety, and all conditions surrounding that would include 90 days of intensive supervision after your release. Okay, that of course you would have to attend weekly group counseling at the probation counseling center. That you would have to submit to polygraphs to ensure that you're complying with your conditions, maintaining sobriety, all those things. Are you asking the court to amend your conditions to include those things? Yes, sir. Okay. Now, are you asking the court to do that because that's the decision that you've made today, and not because you feel like you're being pressured, forced, or something that you have to do? And I understand, Ms. Roberts, you're not saying you want to go, but you're saying that you're willing to go under the circumstances as they exist in your case. Is that correct? And I understand that it's a difficult decision to make, but you've weighed your options and you understand the consequences for what may lie ahead if you don't submit. Is that right? But are you making this decision based on your consideration of all of those facts and circumstances? And you're telling me today that even though it's nothing that you want to do personally, it's something that you're willing to do and that you've made that decision on.
Yes, sir.
I know you have family here that talked with you throughout this process, is that correct?
Yes, sir.
Have they given you some guidance and their advice on these matters?
Yes, sir.
And you're not represented by a lawyer.
No, no.
You understand that you do have the right to hire an attorney if you want to.
For this sanctions, probably,
Yeah, you can hire an attorney at any time you want.
well, I can't afford it, so, no.
Yeah, there's no motion or anything. It's not an adversarial proceeding right now, so you're not entitled to court to a lawyer, but I'm saying you can always hire an attorney. If you feel like you want to, understand your legal rights better.
So,
So, are you ready to go to the safety program?
yes, sir.
You understand, Ms. Roberts, that that is a lockdown facility that is run by the Texas Department of Criminal Justice. And you could be there for minimum 6 months, no more than a year, but it's typically 6 to 9 months. And part of this program is obviously education. It's to help individuals like yourself who have an addiction learn how to combat that addiction, learn how to change your lifestyle, learn how to change your mental aspects, the way you think about things, the way you cope with stress, all of those things. Safety is only good for people who are at that point in their life that they're ready to change and to try. Is that you?
Yes, sir.
All right. Then the court is going to grant the amendment to the conditions of community supervision for Ms. Monica Roberts to include additional court costs and placement in the substance abuse felony punishment facility. All conditions surrounding that, including weekly group counseling at the Van Zandt Community Counseling Center, and the addition of polygraphs before the completion of the ISP program. All right, so Ms. Roberts, what I will do for you today, I'll do it for you out of grace, but I want to make sure that it's not going to be a mistake on my part. Okay. I'm willing to let you come back at 1:30 out to the Justice Center, and then they can take you into custody. Then you can go spend some time with your family. You can have lunch, talk about these things for a couple of hours, and then show up at the Justice Center at 1:30.
Okay.
I'm willing to do that, but what I don't want to do is I don't want you to go drink. I don't want this to be a stressful situation and you think this is my last opportunity to take a drink before you go into rehab. That would be counterproductive. That's not what I want. But if you want to spend time with your family, with your daughters, your mother, and go have lunch and say some temporary goodbyes until you get in the program, I'm willing to do that. Is that something you can handle?
Yes, sir.
And so I'm going to order you to appear at the Van Zandt County Justice Center at 1:30.
Okay.
Okay.
Yes, sir.
And at 1:30, we'll have these conditions out there. They'll go ahead and take you into custody, process you there, and then you'll just wait there. Do you know what the wait times are? I'm talking about
In a couple of weeks.
so a couple weeks, probably at most, before your bed is ready. But that's part of the program. You don't have to wait. The only way that you get in that program is that they know that you're going to be submitted when the bed is ready. And the only way to do that.
Okay.
Okay. So that's what I would extend to you. I think you can handle that. Coach, you'll be with your family until that time?
Yes, sir.
Okay. All right, so come over here and see Officer Mature again. She'll get a copy of this and then just come out to the Justice Center at 1:30. You won't see me then, but they'll go ahead and they'll take you in there and get you going. Okay. And whenever she's finished, she'll come back out that way. Thank you for your help. Appreciate your time today. All right, court recalls cause number CR 22-299, State versus Katie Renee Williams. Ms. Williams was set for motion to adjudicate today, failed to appear. Her name was called loudly and distinctly 3 times in the courthouse with no response. Earlier this morning, the court issued a judgment not citing against Katie. The bondsman for Ms. Williams has contacted the court and indicated that Ms. Williams may be ill and unable to appear in court. Court's going to take the judgment not signed alias KPS under advisement until 5 p.m. on Thursday, February 15th. And on proper production of medical documentation, court would withdraw that. Court's going to stand in recess until 1:30 and resume its docket at the Justice and Council.